Well, good morning. Good afternoon, ladies and gentlemen. My name is Lee Norman. I'm the Chief Medical Officer at the hospital and have the pleasure of introducing our speaker today on a pretty interesting topic, the art of negotiation and mediation. His first challenge was negotiating a parking spot here at 39th and Rainbow, and he's passed that, so with flying colors. The Honorable Judge Kevin Moriarty is both an Ichabod and a Jayhawk. And a Kansan. He's born in Topeka, did his undergraduate and law school at Washburn University and a Master's of Public Administration from Kansas University. He's got an impressive legal background and career. He was in private practice of law with over 100 trials to his credit before being appointed by the then Governor Kathleen Sebelius to the bench, the Johnson County District Court in 2004, and I have a hunch that of all the mediation and negotiation that he's done, probably none has been more relevant and important than in the raising of 3 daughters. So I think with that, I'll turn it over to
Thank you,
Judge Moriarty.
Thank you. You don't mediate with 3 daughters. If you have daughters, you just do what they tell you to do. You try to get by. Thank you. I will. Let me tell you a few things. I have been doing mediation for a long period of time. I was actually certified as a mediator when it first became something that was fashionable, which was over 10 years ago. And then since then, I was in private practice for, like I said, 25 years, and then I went and became a judge about 5.5 years ago. And so I did a lot when I was in private practice, and then when I got to the bench, we found that, and it was by quite happenstance, that I started doing criminal mediations. And I do domestic mediations, and I do child needed care mediations, and I do about 200 to 250 mediations a year. About 150 of them are criminal mediations. And those are, we are one of the few areas in the United States that does that, by the way. And it happened by complete accident, where I used to be a prosecutor for 5 years, and then I was a criminal defense attorney for 20 years. And some advocates were pissing and moaning towards each other, so they came to me and said, "What do you think is fair?" So I gave them my suggestion, and it worked out. And then it happened again the following week and the following week. So as the net result is now I do many criminal mediations, and I've really learned a lot about people during that process. And what I've learned is that the principles that apply in all types of conflict resolution really are not that much different from one setting to another setting. And quite frankly, there are things that you already know. There are things that you've already studied, you've been trained, you know about, but it's something that we all forget when we're in the throes of trying to resolve some type of conflict or dispute. We know that a few things, and one of the things that we know is that there will always be some conflict as long as there are other people that live with us or near us or around us or that we have to work with. Ted Kaczynski was by himself, but he was still able to find some conflict. So we know that whenever there's people, there's going to be some conflict, and it's just depending on the personalities how great that conflict can be. We also know that in your personal life, this does not necessarily apply, but in your work life and your other aspects of life, that if you can manage conflict, you can certainly manage the people. If most of you would look back to where your problems are in your office or what you're doing, it's on a conflict probably that takes up more time than it deserves, and all you want is for that conflict to go away so you can start dealing with something else that's important. But getting over that hump sometimes is a bit difficult because of the personalities. We know that how we can manage conflict, and all of these are good at various times. There's many, but these are the top 5. We can either ignore it or avoid it, and if we ignore it or avoid it, sometimes it goes away, so it's resolved itself. And sometimes that's not a bad method. If you're an active manager, it's not a good process because usually the people you're managing hate that type of principle, primarily being the way you manage, is to let things resolve themselves. But sometimes it's the easiest way to do it. To accommodate is what we probably do often is it's the squeaky wheel type thing, where the person who complains the most, sometimes it's worth it just to give in to them, let them have what they want. And that happens sometimes, and it works. We also have compromise. Now, compromise can take many forms, but one of the forms that it usually takes is where we just split the baby. Where we say, we get 10 items, and both of you want all of them, and we end up agreeing to give 5 to one party and 5 to another party. And compromise is something that I think most people expect, and they're happy when something else occurs. So that is something that we see quite a bit of. The easiest way to manage people, if you don't have to worry about what they thought of you, is simply to dictate to them. Tell them what they're going to do and get through it. Now, that is not the primary method of trying to manage folks, but it is one way that can be done. And sometimes there are certain things that's the only way you can manage, because there are certain things that are not up for debate. There are certain things that have to be done a certain way, and they are going to be done that way. In those situations, it's usually a matter where you just have to explain to the people why it has to be done that way. You're not asking for an open discussion to discuss if that's the right way or whatever, but simply that you want to communicate that is the way it's going to be done, and this is why it has to be done. And then, of course, the one that I work most with is trying to collaborate, where we listen to what everybody has and what they're saying and try to figure out what they all want. What they say they want and what they say they need may be completely different than what they really are arguing about or what the issue is. These are things that, by the way, that not only do we see in our personal life and in our public life, but in about every facet where there is people that have to work with people, whether it be in government or in your own situations. And it could be everything from a country club to the President of the United States. There are 5 simple steps that I would suggest, and they don't have to take long. They don't have to take long at all to get through them. And one is to listen and observe what is being said. And we all know that that's what we're supposed to do. We just need to be reminded sometimes. Sometimes we're so busy doing other things that we don't hear what's being said, or we're not observing what's being said. And the net result is the people think that we are not listening. That happens to judges all the time, by the way, because we are multitasking. Almost everything we do now, by the way, is on the computer, and we have a computer screen. And I tell folks right up front that all the pleadings are on the computer. Sometimes I'm reading the pleadings. I also have all the case law on the computer that I can pull up. So when they think that I'm not listening to them, that's not true at all. I tell them I'm listening to them, but sometimes I will need to look at the computer because that has the information I need. And you probably have that same situation where you're multitasking and you're not listening in the way they would like for you to be listened. Another way to resolve it is when you listen and observe what the person is saying, try to really identify what the issue is. I think that all of you can relate to the fact that many times what the argument starts over, what the dispute seems to be about, is not what it is about at all. It's about something completely unrelated. And we see this frequently in when I do divorce mediation, when I do business mediations between contracts and mediations between corporations, or I've done a mediation between a city and a county because they both have certain needs and wants, but what they were saying was completely inconsistent with what they really wanted done and what they really needed to have done. So if you can identify the issue, by the way, you can usually resolve the problem. After you listen and identify the problem, you might want to respond in some fashion. Everybody expects a response, do a response. Anybody who's ever been to a therapist knows they don't like to go to a therapist who doesn't respond. They hate that blank stare. They like to have some type of feedback, like, am I really crazy type of deal. So they want feedback. So give them the feedback that they need. The matter has to be resolved. So try to figure out what it is that they want, what it is that you want, or what the parties are trying to fight about, and see if you can resolve it. The chances are that you folks will be able to do it. You're all intelligent. You can figure out what the issues are. You can usually resolve them. It's more difficult when it's a moving target, where the issue seems to change. And you may have dealt with folks like that, where they start off down one road and you think you've figured out where they're going and where the next turn is, and then all of a sudden they do an about face and you say, what in the world are you talking about? That is not what I understood the issue was. And all of a sudden you're dealing with somebody like that. So for most of you, try to identify the issue and try to keep the initial conversation on that issue. In all matters, you need to restate what you believe the issue was and what you believe the agreement was. And that's important because a lot of times we think we've heard what the people have said, and we've stated, sometimes using their own words, what they were saying, only to find out that what they were meaning was something else. When you do criminal work, by the way, that happens all the time. And something new is last week, a guy was doing criminal mediation. He said he whacked his bitch. Now, my first initial thought was he slapped his girlfriend. That's what most of you would think. But I learned that whacking is also the same thing as boinking, or having sex with. So when he was whacking, he was having sex with his girlfriend, who he refers to as a bitch. So you make sure you understand what they're really saying happened, so restate it so that you can have a clear understanding and there's no confusion. By the way, in criminal matters, we always restate the issue and we always restate what the solution is, so there's no confusion. And we do it in a fashion where we can say it out loud so everybody can hear it and everybody can understand it, and give them the opportunity to say, that's not my understanding. That's not my understanding. Now, there are several reminders I want to give you. And the first one is be courteous and constructive in your comments. Sometimes that's hard to do, I know it. There are certain folks that we deal with that make it really difficult to be courteous and constructive sometimes. We know that, but if you're wanting to get something resolved, you're not going to go very far if you refer to them as a bitch. Okay, it doesn't work real well. And I remind people about this all the time when I'm doing criminal mediation or domestic mediation. Usually when you're doing domestic and criminal, you hear a lot about the words are bitches and assholes. And we've always kind of assumed that they're gender specific. But they're not. So if I use those terms, they're interchangeable. Now, you have to be an active listener. And to be an active listener, the person has to know that you're listening. And how will they know that? You can restate what they've said, you can rephrase it, or you can paraphrase it. I would suggest that you not use the exact same words, because sometimes their words may not be like whacking the bitch. Well, so then did you whack the bitch? And it'd be kind of like a my cousin Vinny type moment where you're talking about two different things. So then you hit her? No, I didn't hit her. I had sex with her. Okay, so then you had sex with her. So that shows you're listening, but at the same time, giving them the thoughts that they were trying to convey. Listen to what is said and not the words spoken. A lot of times people are angry and they have a lot of words, none of which really are the issues. A lot of them are hostile words or angry words. And so listen to what the words are really, what they're really saying, and not the words that are spoken. It is easy to get hung up on words. I was talking to Dr. Norman. He's from Seattle. I was in Seattle last week, and as he could tell you, there's some hills there. And I was coming down a hill, getting ready to go to dinner down by the pier, and I was actually wearing these shoes, and they got a slick leather sole on them. And I slid and fell on my butt coming down this hill. And there's a young African-American guy behind me, and he says, "Are you all right, old man?" Well, my initial thought was, I am not an old man. Okay? But, you know, when I think about he was concerned, that was what I heard him say. He wasn't laughing, and he came up to help me. So I was just an old man to him, and I suspect from behind, I hope from only behind, that I might look like an old man. So the words that he spoke may have offended some, but really he was just trying to be caring and compassionate, and he was in fact helpful. You got to focus on the issue and not the person. I usually say that even an asshole can have a good idea sometimes. And that's the truth. We sometimes turn people off because we don't like them. There is nothing they're going to tell us that we're going to like because we just don't have very much respect for them or very much worth for them, and the net result is we don't want to hear what they have to say. Well, sometimes they do have something to say, and sometimes they do have information that can be valuable. So make sure you do try to separate the two. Again, as I've told you, these are things that you all know, and sometimes they just need to be reminded of. To be clear and direct in your responses. You know, I am not one to sugarcoat. I think that it's a mistake. I tell people I think it's a mistake when they try to sugarcoat things because your words, even though I've told you to hear what is said and not listen to the words, if you try to sometimes make a statement and try to make a really difficult, like somebody's getting ready to pass away, it's hard to sometimes say, no, your mom's not going to make it. Your mom's not going to make it. But if you try to say it in words that you would like to hear or you think they want to hear, like, well, I don't know how she's going to do, but we're going to play it day by day. Have you ever said that? When you know the probabilities are high that that's not the situation. You're not being clear and direct. People do want to be heard clear and direct. They may be angry with you initially. They may be upset, but they need to hear what the real score is. And by the way, this is really important in every type of mediation that you're dealing with people who have misperceptions about what is reality. In criminal matters, you have to be real clear and correct on what their exposure is and what their outcomes will probably be. In divorce matters, you have to be real clear about if you go to trial, what do you think is going to happen? Well, that's not going to happen. You have to be real clear and direct. And in corporations, when we're doing corporate resolution matters, we have to be real clear that, that may be the way you feel and that may be accurate as far as you're concerned, but as far as the law is concerned, as the judge is concerned, that's not going to happen. There are going to be differences of opinion. In child custody matters, for example, it is entirely possible that we will have two great parents that just see a different way of raising their children. And they both have good ideas. But it's a situation where it will only work if they both agree to disagree. By the way, frequently this has to do with one of the biggest disputes that we have as judges to resolve is when we have good parents, is a lot of times on either a move-away situation or on a medical issue. A move-away situation, common situation is somebody works for Sprint, they've been there for 10 years, they lose their job because of Sprint's scaling down, and all of a sudden they're going to have to start looking for a job in Florida. We have two good parents, what do? So sometimes there's going to be a difference, and you're just going to have to respect that they're never going to agree, and you're just going to have to see what happens. The other one is on medical treatment, very common for trial judges. Of all the common things, the most common one is whether or not the kid should be on medication for ADHD, for example. And that usually is polarizing to some parents. One size doesn't fit all. If you're working in a mediation, you're going to have to assess the folks and the people and use your common sense and use your creativity to try to figure out ways to resolve whatever it is that you need to resolve. I tell people this every time when I go to speak. There isn't one plan that works for everybody. Try something new. If it works for you or if it works for that occasion, that's all that really matters, is it work then. If you try to get into a framework where you use the same pattern every time, it's not going to happen. It's not going to work because everybody's not the same. Especially in criminal matters, especially in domestic matters, it just doesn't work. In work matters, you may have some people that you've been working with for 10 years, so you get some expectations of how they'll respond. So you may be able to use a pattern that's fairly consistent. But whatever it is, make sure that you always consider whether or not it is the best way to go. This is something we've all heard a million times, so we start off with I and not you. It's probably the most commonly forgotten issue that we know. If you start off with I feel or I believe that such and such is true, it's a lot easier than to say, you did this wrong or whatever. Everybody will tell you that. We've learned it throughout college, throughout professional school, but it is probably forgotten so often that it needs to be mentioned again. This is one where it kind of relates back to the other one about your mother is not doing well, about modifying the message because of the reaction of the person. This is something when I speak to judges, I tell them all the time. If you're getting ready to make a ruling and make a decision and start telling the litigants what your decision is, someone might start crying. It's not uncommon. Well, sure as hell don't want to change your words. I mean, if all of a sudden, golly, that person's crying, let me try to make them feel better and let me change what I'm saying. You can't do that. You need to make sure they hear you. You may have to use words that they can hear you, but you don't change the message. The message has to be consistent and clear. Frequently people, we know by observing them, they don't like what we're saying, and so that our human nature is to try to make them feel better, so we try to say things that we think will help them, and it's not at all. They're still going to be upset with you if they don't like what you're saying. They're still going to be hurt. They're still going to be whatever their emotion is. Remember that you have to resolve the issue. It may not be a permanent resolution. It may be a temporary resolution, but there needs to be some resolution. A temporary resolution is better than no resolution at all. If you go back to your workplaces and talk to everybody and say, I know we've had this problem, but I'm not going to resolve it, they're not happy with that. They would rather have a temporary result or know when the result's going to be accomplished than no result or no end in sight. This is the end of this part, but what I want to tell you is that mediation, I believe, can work for every type of group, whether it be in your settings, trying to communicate with folks in your office or resolve issues with folks in your office, or maybe when you're dealing with in your clinical practice with your patients. I know that it works. I do mediations, I think, in the toughest type things is, for example, in criminal where there's somebody who may have killed another person, and I deal with the deceased family and the criminal defendant, and frequently we're able to get some dialogue and discussion and resolution of it. We know that in criminal matters, for example, we know that there's a lot of emotions, and that the one thing I think I've learned, and it may impact you at some point, is that forgiveness can be extremely important. Sometimes the defendant needs to be forgiven, and sometimes the person that has been the victim of the crime wants to hear what that criminal defendant has to say so they can decide if they truly are remorseful. I think that most people are, when we're in a dispute, we always want to make sure that what we're hearing is factual and truthful and honest. And that can all be accomplished, but you have to create the environment for that to take place. I was told to talk for 25 minutes and a half. Now, do you guys have any questions at all? Yes?
You mentioned the 5 methodologies: ignoring, accommodating, compromising. You've got the collaboration, and then you mentioned 5 steps. Would you review those real quickly?
Yeah, the 5 steps were to just those, to listen and observe, to listen to the person. In fact, when you go to any type of seminars or to any classes, they'll tell you that you should always listen before you talk, and that makes sense, and observe at the same time. Then, to identify the issue, you can only identify the issue if you really are listening to what the person says, and then to respond to what they've said, to let them know that you've heard them and that you've identified the issue, and then to resolve it and restate what your resolution of the discussion is. And that is about every type of collaboration program you go to, or every type of conflict resolution program you go to, you'll hear those are the same 5 steps. They may say it differently, but that's the same 5. And it doesn't need to take very long, by the way. Sometimes you just need to listen and say, yep, you're right, let's start doing it this way. And you've resolved it. By the way, when somebody is angry, and you've probably worked with folks like that, or dealt with them, the easiest way to take anger out of of what they're saying is to let them speak for a while, and then to restate what you've heard. And sometimes it's amazing that when they hear what they're saying, it's really not that big of a deal. And they've got all excited about something for nothing. And that's real true where it's emotional, specifically divorce cases. If you say, this is what I'm hearing you're saying, and it's just the way you feel, and they say, yeah, and you say, well, it's something much simpler than this, and it really shouldn't create all this hostility or anger. So letting them speak and get it out is very helpful. By the way, in criminal matters, I do this frequently, where there is maybe a young man. Perfect example is an 18-year-old guy who was aged out of the foster care system. He went to live with his father for the first time ever, primarily because his dad had been in prison. His dad had been out 3 months. At the same time, he aged out of the system. He went to stay with his dad. His dad violated and went back into the prison. The kid didn't have a place to go. Gets involved in a purse snatching, and that's a robbery. And he had prior criminal history. So here's an 18-year-old that stole the purse with $15 in it, and he was facing a 7-year sentence. Well, it's good to have both people together, because I don't think the victim, who's a nice lady, elderly lady. She never anticipated that would be the outcome. And the kids certainly didn't. So a lot of times we know that the pigeonhole that we have people fitting in doesn't really work. So that's why we do the criminal mediation, is to make it that. And that's a good example where if we let the lady who was very angry speak for a while and then hear all the facts, it really deflates the anger. So, any other questions? Yeah.
In my job, I deal with some kind of negotiation or a conflict resolution almost every day. And, and it's usually with very high-performing people. And I'm always amazed at a couple things. One, how entrenched people are in their views. Two, how they very well may be creative people at other aspects of their life, but they're not demonstrating it at that moment. So the question is, how do you get beyond an impasse?
Again, you're absolutely right. We see that a lot where people are very bright. I see that in corporate disputes all the time. But you have to, I think, go back to identifying the issue and figure out why it is that they're so inflexible. And there may be a reason for it. And most, at the core of all situation like this, there's usually something that's fearful or frustrating or unknown to an individual that creates the anxiety. If they had a better understanding, maybe they wouldn't feel bad. There are some people, this works for about 90% of the people, probably 95% of the people, probably about 98% of the people that you work with. There's that 2% to 5% that are just jerks, that it's not going to work. You can try to do whatever, but it's never going to work. But identify the issue and figure out what they're really upset about. And sometimes people that are embarrassed about them, sometimes they take a position and they're actually embarrassed that they've taken a position. And if you have them try to identify why they've taken that position, you might find that it's a fear of losing status or a fear of losing something.
Would you speak to how you actually go through these steps? Do you keep everybody together the whole time, or do you separate them? Or?
It depends. No, I usually start off. In criminal matters, by the way, I never start off together. Never. In domestic matters, I might, only to identify what the issues are. And the reason it's just helpful to me, for example, if I get folks in there and I have husband over here and the wife over here, and I said, do you guys own a house? And the wife says yes, and the husband says no. Shit. This could be a long day. I mean, they can't agree if you own a house. So I usually start just to get a sense of how close we are to where we are. But then I'll separate and then go through things to find out what the real problem is. Sometimes, by the way, it is they want to make, it's as simple as they just want to have a pound of flesh. Okay? And if you let them think they've had their pound of flesh, and if they believe they've had their pound of flesh, it can work. I did a divorce recently with people very wealthy, and a foundation was set up for the wife with a significant sum of money into it. But it really benefited everybody. The guy too, because it was to help a cause that he was liking as well. Yeah.
I wonder how you resolve situations in which one of the two parties is not negotiating in good faith.
I call them on it. I do. I give them it's called reality therapy. I give them what I think the facts are. Like, for example, here's a laundry list of facts that we can agree upon. Is that correct? Yes. Here's facts that we don't agree upon, and here's what we're trying to accomplish, or here's what the law is, and how do you think these facts play into the law? If they don't negotiate, and they won't negotiate, you can't make them, but you can make them see that they're wasting their time and energy. Most people there are many people that come to court not wanting to negotiate, and I tell them I give them the reality of here's what your facts are, here's how that works with the law, and by the way, for you to get from this point to the next point, it might cost you $10,000 in attorney's fees, and you're fighting about a $5,000 deal. So that works. There is that 5% element that it's not going to work. And by the way, I do ethics teaching as well for attorneys. I told them, and I truly believe, and we get to choose who our clients are. You folks don't. But you know, if somebody's been to 3 other attorneys and they've come to you, you should not take them. If they can't get along with three attorneys, there's something wrong. So that's that 5% element that you don't want, because there's nothing you're going to do that's going to please them, and they're just going to complain. So don't hire those people. Any other questions? How many live in Johnson County? Here. Great. Johnson County is progressive in every faction. We have the first, we provide mediation for free. The judges do to all civil, criminal, domestic, and sync. We're the only county in Kansas that does that. We also have a movement in our system that if you do have something that has to be litigated, and sometimes there are some times that where honest people cannot agree on the outcome, and it has to be litigated. And the good thing is in Johnson County, we are able to get people in and out of the system. And if you say you need something done, for example, within 90 days or 180 days, we can accomplish that. So you're very fortunate to live in Johnson County, because we do bend over backwards to try to accommodate the litigants and the attorneys. Anything else?
Well, thank you for coming out today. And the rest of the hour, whatever we have left, is for networking among yourselves, discussing issues that may have come up in your own departments or your own careers, or visiting with the judge about some specific examples you don't want to discuss in front of the room, I guess. Thank you.